This has always been a bipartisan bill going way back to 1986. As I complimented Congressman Berman for helping me with this in the House of Representatives in my first term in the United States Senate. But Durbin, Leahy, and Kennedy working on it very closely this time, and all members of this committee further backs that up. Today, the False Claims Act is the government's most powerful anti-fraud tool, recovering more than $64 billion in taxpayers' money since the amendment passed in 1986. The Justice Department has even said that the False Claims Act is the #1 tool for fighting and deterring fraud against the government. Now, more than ever, the False Claims Act is necessary to combat cases of fraud, waste, and abuse in government funds. In 2020, the Justice Department opened a record number of False Claims Act cases and investigations due to sweeping number of COVID-19 related allegations. This is only beginning. Immediate action to strengthen the FCA provisions is absolutely essential to protecting the taxpayers' money. And this is an example of the Congress being a check on the judicial branch of government. And the sad part about this is, because I keep referring to the Escobar case, we're in a problem just because a dicta stated in the Escobar case, not because of anything that's very clear in the decision. And thank God not every court case since then has relied on the dicta. Some of them have gone contrary to that. But since the Supreme Court decision in Escobar, courts have grappled with how to evaluate the government's knowledge of alleged fraud when determining whether the defendant's misconduct was material to the government payment decision. So here we make very clear we don't have to rely on different courts interpreting it in a different way. These amendments would clarify misinterpretations created by the Escobar court by clarifying what should already be common sense. In other words, that common sense is just simply getting back to what we intended in 1986. The government's continued payment of a claim, despite knowledge of fraud, is only probative of materiality when no other reasons can be articulated by the government's continued payment. Now, I know some of my colleagues believe the government's decision to continue paying a claim should automatically be dispositive. They have bought into what is now the healthcare lobby's lies that not only doing so will increase healthcare costs, but let me say to you this: were healthcare costs highest prior to Escobar? Of course not. These are the same groups of people that hike drug prices on seniors while defrauding Medicare at every turn. Last year alone, healthcare fraud accounted for about $8.1 billion of false claims recovery. I think we get an average about $3 to $4 billion a year from this legislation. So it looks like healthcare costs might even take up more than half of the reason to keep this legislation strong. So we have a chart here that says two things: where healthcare fraud is, and also to show that this law has a disciplining effect on people that are inclined to fraud. Because when we first started this legislation in 1987, it was because we exposed $750 hammers and $600 toilet seats in the spare parts purchasing by the Defense Department. That made a very strong case to strengthen the key TAM provisions of this legislation. And you can see how defense spending, the blue line here, has leveled out. But it hasn't had the same disciplining effect upon healthcare, although I assume without the False Claims Act, you'd have even more fraud in both of these instances. So I hope you understand that it isn't only getting back fraud money, but what we save as a result of the disciplining effect on people that might be fraudsters, that won't be fraudsters, because they might get caught at it and get it back. So let's see, where did I leave off here? Last year, so out of this $1.8 billion, most of that money was returned to the Medicare Trust Fund. So this not only strengthens, just protects the taxpayers, but it protects the Medicare program. I also want to point out that I spoke to healthcare systems in Iowa, and we're not aware of a single instance where this action would cause harm or be unfair. So I only say that because in my state, we don't have this problem of worrying about whether we have a strong False Claims Act. So I think it confirms, if you play by the rules and don't attempt to defraud the government, this bill will not impact you. Simply relying on the government's payment history without further context will inevitably lead to erroneous outcomes and increase in fraud. These changes are more important than ever. Over the last several months, the government has spent trillions of dollars towards relief programs and stimulus packages in response to the pandemic. Given the circumstances, then, it is highly unlikely that the government would discontinue payments for services under these relief programs. So for those of you that think that the government continue to pay something, even if they know about fraud, relieves the fraudsters of their of being condemned for that fraud, you can see why when we appropriate money to stimulate the economy, help people that are hurt as a result of the virus, we put these trillions of dollars out there and the government keeps paying them, well, they aren't going to cut off the payments. So if there's fraud, you get the fraud after the fraudulent act has been paid. So if you're saying that they can't be prosecuted under this legislation because they continue to make the payments, and that's what materiality is all about, you can understand that you're not going to have the discipline effect of this legislation. The proposed amendments that we put before you in this bill ensure that fraudsters will not get away with enriching themselves at the expense of the taxpayers. The amendments further, now on a second point, the amendments further clarify Congress's intent of a common sense definition of word hearing, quote unquote, the word hearing, and require that a hearing be provided before the government can dismiss the claim. Under this provision, the rational basis test is codified to prevent the government from dismissing a case over arbitration. Now, if you want to read about all the cases in the False Claims Act, you can read them right here in this book. So in regard to this hearing situation, we've had 4 different interpretations by 4 different circuit courts on what the meaning of a hearing is. Well, isn't it our responsibility to make clear what Congress means by the word hearing? So these provisions are intuitive and reiterate what already exists in our law, or was intended to exist in our law. Due process requires the government to explain its reasons for a dismissal request. Ultimately, the federal judiciary maintains discretion over the time and resources allocated in each case. A judge cannot waste time on hearing a case they cannot act upon. The question before us today is, as we work to pass this legislation, it's this simple. Why should the taxpayers pay the price for bureaucrats who fail to expose fraud against the government? In other words, if you're raising questions about materiality and the government continues to make payments, and the fact that they know about fraud, they continue to make payments, that's some reason that you can't collect that fraud money. It just doesn't meet the common sense test. So if bureaucrats aren't doing their job, continue to pay the money, they know about fraud, you can understand that that just isn't the way we ought to be running the government programs. So I guess I'm happy to, from time to time, like Senator Leahy and I've had to do, I don't know how many times we've had to pass this type of legislation, because some court just gets it wrong. And you've helped me with that, and it's been bipartisan ever since we got this legislation passed, because you aren't going to be caught under this legislation unless you are a fraud, or fraudulently taking money. So what's wrong with that? I yield.